All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 2024-0839 involving potential amendments to Florida Rule of Criminal Procedure 3.190.
Good morning, and may it please the court. Honored to be here. I am Judge Ballone, chair of the Criminal Court Steering Committee. Our committee, as you know, has made a number of proposals to modify Rule 3.190. And how did this start? To us, it never seemed practical that a motion to dismiss had to be filed before or at the arraignment. That's what the rule currently provides. And we've actually never seen anyone do that before, and the rule has been uniformly ignored for years. So it seems appropriate to perhaps amend the rule. Our proposal is that a motion to dismiss must be filed before a deadline set by the trial court. Of course, there's going to be a good cause exception for that. However, the motion should be filed or must be filed before jeopardy attaches so that the state has the ability to appeal an adverse ruling. Now, immunity motions are a whole different animal, and the reason is that they are evidentiary and they can be very long. They are basically a trial before the trial, and believe it or not, at times lawyers will file these motions on the eve of trial or even on the morning of trial. And why do they do this? For the worst possible reason, because they can. There's no deadline in the rule except before or at the arraignment, which is universally ignored. And the fourth DCA in Acosta Figueroa ruled that that motion can be filed at any time before trial. So the court, of course, can fix this. We propose that immunity motions to dismiss must be filed no later than 30 days before the trial. Of course, there's a good cause exception, and there will be good cause from time to time, of course. And there is precedence for this in the rules. Williams rule, child hearsay, alibi defense, battered spouse syndrome defense, all have filing deadlines before trial, either 10 or 30 days, and it seems to work. Now, after we dealt with the deadline issue...
Judge, could I ask a question about that? Would you think that there is, could you kind of address the concerns that there are differences in the defense versus an immunity granting provision? Because those are kind of two different things, and I think they've raised some interesting concerns about that. That can we limit immunity procedurally?
Well, I think you can. I think it's a procedural thing. They're obviously very closely related. They're based upon the same facts. So and it'll be the same facts that come out. It's just a matter of the issue of who has the burden of production, and I'll get into that a little bit later, and what the burden of proof is. Obviously, it's always the state. It's either by clear or convincing evidence or beyond a reasonable doubt at the trial. But I think even if it's an immunity issue, I think that the court can still deal with it procedurally. All right, well, after we dealt with the deadline issue, we decided to review the entire rule. We saw that a lot of that language was antiquated. As a matter of fact, there were some portions where we didn't even understand what it meant. So we tried to understand what it meant, and then we tried to make it easier for everyone to follow. So I don't think there's a whole lot of controversy about that. But one proposal that has generated discussion is the requirement that we're proposing that all motions to dismiss, including immunity motions, must be sworn by someone with personal knowledge of the case. So it doesn't have to be the defendant. Obviously, it can be the defendant, but it can be a witness who was there who has some knowledge of the facts. And the purpose is to make sure that these motions are made in good faith and are somewhat reliable.
What about the argument about, and I think this comes up elsewhere, that these are extra statutory requirements that the committee, which I commend you for taking on the project and doing such a good job of it, but why shouldn't we just be guided by what the statute requires?
Well, that's a good question as far as what the statute requires. Now, the DCAs say that the statute is unambiguous, but the DCAs find different meanings. They don't agree on what the meaning is. So, as you know, the applicable statute is 776.032, subsection 4, and it basically states that a prima facie claim of self-defense immunity must be raised by the defense at a pretrial immunity hearing.
Right, but it doesn't say anything about who needs to be sworn or...
Right. Right now, the DCAs have handled it some. And I'll just go over that very briefly, and that is in Jefferson, the second DCA ruled that the defendant only needs to make a claim, in other words, just file a motion. And then the third DCA in Casanova followed Jefferson and held that the motion did not have to be sworn. Now, the first DCA took a whole different approach here in Freeman, where they held that, in their view, the plain language of the statute means that the defendant must present prima facie evidence at the hearing, because that's what it says, at the hearing. So they think that the defense has to put on sworn testimony at the hearing. They have the burden of production, and if they show a prima facie case, then the state has the burden by clear and convincing evidence to show otherwise. So in their opinion, unsworn allegations are not good enough. They think that there has to actually be sworn testimony at the hearing. There was some legislative history to support that. We have that in our report. Now, our proposal is not to go as far as the Freeman case. We are just proposing that all motions to dismiss, and that would include immunity, self-defense motions, should be sworn. We just want to make sure that they're done in good faith and that they are somewhat reliable.
It's a matter of judicial economy. That if you can't get somebody on, am I correct in understanding
Correct.
that if you can't get somebody to swear to it prior to the hearing, you may come to the hearing and it's all just, it ends up being nothing.
Right, and here's the other thing. I'm not saying this happens every time, but lawyers sometimes will ask for an immunity hearing just to get extra discovery, because the more times you have a hearing, then the more inconsistent statements you're going to have. It's just kind of inevitable. And the other thing that they can do is they can wear down a witness's cooperation, because if you stop and think about it, they have to give statements to the police, state attorney investigation, maybe a grand jury, depositions, immunity hearing, and then the trial. And a lot of these involve drug deals gone bad, where everyone has a gun and somebody shoots somebody because somebody gets disrespected or whatever, or they're gangs that are shooting at each other. So the chances of getting these witnesses in every single time is not very good. Obviously, if it's a good faith immunity hearing, we have the immunity hearing. That's the law. But I think we should just have an assurance that it's made in good faith and that it's somewhat reliable.
Would the people swear, like the defense, be able to rely on the sworn statement as evidence in the hearing?
Yeah, that's our proposal. Just that it's a motion. It's sworn. There could be an affidavit by another witness. It can be with the defendant swearing to it, like what happens in a C-4 motion. I mean, just a swearing like that. And then our proposal would be, okay, here it is. It's sworn. State, you have the burden of proof by clear and convincing evidence, and you go. Now, that's not exactly what the Freeman court says, but we're not proposing anything that far. The Freeman says that the defense has to put witnesses on at the hearing. That may be dicta, but they said it. So
Essentially the statements could take place of any live testimony in your mind that were in the motions.
Right. Now all it has to be is an unsworn motion. So, all right. Thank you. And if I have any time for rebuttal, I'll be back. Okay. Thank you.
Good morning. May it please the court. John Eddie Morrison on behalf of the Florida Public Defender Association. I want to address three aspects of the committee's proposal: the sworn statements, forfeiture, and good cause. Sworn statements. I believe the committee's proposal, and if I heard the judge correctly today, he's proposing to essentially reinstitute a C4 procedure for immunity motions, which I believe this court ruled was inappropriate in Dennis, that the judge would look at these motions and make a decision based on the motions to whether you ever get a hearing. That, of course, is not what the statute says. The statute says that your prima facie case is made at hearing. And frankly, if you can't come up with your prima facie case at your hearing, then it's a very, very short hearing.
How would you respond then to the committee's argument that there exists essentially a circuit split on this issue, and that if we sort of don't deal with it in amending the rule, we're sort of whistling past the graveyard?
I appreciate the committee's position. I'm not sure there is actually a circuit split, but that aside, the circuit split, if it exists, is on what happens at an evidentiary hearing. Neither Freeman nor Jefferson nor any other case in Florida that I know of suggests that there needs to be a sworn motion before the hearing. There needs to be some sort of showing of prima faciality to even get to a hearing. The legislature said very different. The legislature said, and this is the language out of 776.0324, prima facie motion raised by the defendant at a pretrial immunity hearing. That's the statutory language. And I would urge this court to follow that statutory language. That's what the legislature did. That's sworn motions. I'm going to move on to forfeiture unless the court has other questions. This proposal is that motions to dismiss would be decided on a procedural forfeiture rather than on the merits. This is antithetical to everything I know and have ever read about Florida law. Florida law always wants every case decided on the merits.
But all sorts of substantive rights that parties have are constrained by procedural limitations.
They are constrained by procedural limitations, Your Honor, but I can't think of any other place in criminal law, certainly, where we have crime, justice, punishment, liberty at stake, where a procedural...
Well, I understand the argument, that incarceration is categorically different, but one might argue that in other areas of law, losing your life, your business, your child, that's all, and everything's constrained by procedure.
Well, it is constrained by procedure, but I can't think of any place where it would be decided where a meritorious motion would be procedurally forfeit.
What about 3851?
Let me think through that. That's post-conviction, Your Honor.
But
That's
it seems to me
different.
like Justice Sasso's point is correct, that there's due process means process, and so I think your argument proves way too much. It can't be that we don't have some filtration mechanism in the rules for saying this claim, for example, is foreclosed because it has been forfeited. Now, that doesn't say that we don't review ultimately for fundamental error, but it does mean that the rule says that a successive, effort at making an argument that was available to a party at an earlier time operates as a prima facie forfeiture.
Your Honor, particularly in post-conviction, I think that might be different. I mean, quite candidly, the finality of convictions changes the legal landscape quite significantly. But in this context, I would ask very strongly for the court to not build into the rule the forfeiture. The current rule Although,
do you think the immunity motion could be raised in the middle of a trial?
no, Your Honor, because immunity is from going to trial. So by definition,
Well, it would be from continuing trial, wouldn't it? I mean, it seems like your argument. It just seems like your argument about forfeiture just proves way too much, because there's not actually a forfeiture of the defense. The defense is still available, correct?
well, some defenses may be available, but
I mean, assuming it's raised. I mean, again, the defense can be forfeited if you don't raise it appropriately in the trial. You're going to lose the defense, right?
yes, that is true, but it's not decided on a procedural forfeit.
Batson. There's another example of it. You know, if let's say you reach the end of jury selection, and you think, oh, I should have struck this juror for Batson reasons. I'm gonna reopen. I hereby I'm asking the court to reopen jury selection before we swear the panel. Court says, I'm sorry, we're not reopening jury selection. It's that would seem to me to be a pretty good example of how you've got a constitutional right, and yet we have a process, and if you didn't speak up at the right time, I'm sorry, counsel, we're moving forward.
Okay. Let me backtrack and make an argument that might be more palatable to the court. Let's not make that the forefront of the rule. The current rule is pretty good. It has there's a waiver if you don't, but then the exceptions basically say for any fundamental or actually any motion you would care about. That's why the judge says we don't pay that much attention to it, because the exceptions cover everything you would care about. And I think that that's the appropriate rule, is that for everything we can, let's decide it on the merits. And let's not create a procedural forfeit. And I apologize, I'm in overtime.
I know you said you had one more point.
I had one more point. Let me get to it. And let's not count on good cause to solve that. Good cause generally just allows somebody to do something later. It does not decide something on the merits. And everywhere else in the criminal rules that I know of. And it would also create a real problem where attorneys begin to believe that judges like them or don't like them. Parties believe that judges like them or don't like them, and that determines the good cause as to whether they'll hear an untimely motion. That kind of sort of local politics within who's in good with a judge and who's not, that creates a real problem in courtrooms. The law should be applied evenly to all parties, all attorneys. As I'm standing here, I'm looking at this court's motto, sat cito se recte. If right, soon enough. If a motion is meritorious, it's soon enough. And that's the principle I'd ask this court to adopt.
Thank you.
May it please the court. I'm Brian Haas, State Attorney for the 10th Judicial Circuit, here on behalf of the Florida Prosecuting Attorneys Association. The FPAA supports the Criminal Court Steering Committee's proposed amendments to the Florida Rule of Criminal Procedure 3.190. I have personally seen as State Attorney the need for this rule to be amended, and I think that it will, in my opinion, strengthen the ability for people to use the stand your ground law. This in no way would diminish it or take away from it. It's an important law in our state, and I believe it's being abused by folks that are looking for last-minute continuances, ways out of trials, and asserted in situations that are clearly not a stand your ground, but just for the purpose of delay or to drag out the case. And when a case gets set for trial, that's a very big deal. A lot of things happen. Subpoenas are issued, witnesses are gathered, jurors are summoned. Cases that may be on that trial docket are pushed aside by the case that's set for trial. And then at the last moment, when a stand your ground motion would be filed, that takes everything off, and now we've lost the ability to try other cases. When I talk to victims, when I talk to folks in general, one of their biggest frustration with our criminal justice system is the amount of time that it takes for a case to make its way through the system. And things like last-minute filings of motions when they don't need to be. I think we can look at a set of facts and pretty easily understand stand your ground may be an issue here, and it doesn't take a whole lot of investigation to get that to the point. So the 30-day before the trial, I think, is a good place. I would prefer the 60 days because sometimes we are setting trials more than 30 days out. Initially, the FPAA asserted a 45-day from the arraignment deadline, and I think that would be preferable, but we're supportive of any deadline that's going to get us away from where we are right now, which is not a good situation.
What's your position on their forfeiture argument? How do you respond to that?
Well,
namely that I'll be more specific, that this is a different kind of thing we're asking them to forfeit. It isn't it's something fundamental that shouldn't be waived just because of the potential for abuse that you've identified.
I think that it is a very important thing. It's critical to the whole system, and we're looking at this law from the second we're aware of a case. And sometimes they don't even make it into the system because of the respect and the level of importance that we see with this law, and it's very clearly the law of this state. But I think that I read a quote from the Criminal Procedure Rules Committee, and it talked about if a defendant is moving for the dismissal, the drastic result of a dismissal of a criminal case, then I think it just shows the level of importance here. We're talking about not even getting this to a jury, not having the ability for the state of Florida to take this case before a jury of the peers of the defendant, just immunity from the beginning. And I think that putting rules that are going to shore up the process, I think, strengthens the seriousness of the law itself, and I think it helps. It doesn't take away from it.
Well, and it's not fundamental in the constitutional sense anyway. I mean, it's just a statutory immunity, right?
Yes, sir.
I mean, so it seems like the whole premise of that, it seems like it's kind of misapplying the concept.
Well, it seems that the need to have these things in place is what really is helping the whole system process all of the hundreds and thousands of cases that we have, and it takes away some ability, I think, to abuse it. And having the requirement to swear to the motion, and it I think, shows the seriousness of it, and it's going to eliminate just motions that are filed without any real facts that would support a stand your ground motion. So it would be my position that it's an important part of what we're doing, and that we must amend this rule to strengthen our process that we have.
Could I ask you a couple of technical questions? So we all know that state criminal court, you might have 40 cases set for trial on day one for a trial period. Everyone's been subpoenaed. Is your idea or your thought of how this rule would work, is it the first time the case gets set for trial, the second, the fifth? These aren't really motions to continue. They're just cases get pushed because other cases go.
Right.
And so if a case has gotten pushed 6 times, we're now 6 months past when it was originally set for trial. How would this deadline work?
My view is that it's with the date that it's set, and if there's no longer a date for trial, then
The deadline moves too.
I believe that would be the case. And sometimes cases are going to be continued for a variety of reasons, and that's just a fact of our system. But I do feel that the judges play such an important role in this, and if there's something going on with the case or new facts are discovered, then by all means the judge should have the ability to say good cause here, and then we use that in our system many times.
And then extremely technical question, but there was a point raised that the traverse and demurrer of the state didn't have a strict deadline. It just says within a reasonable time, whereas all the other things have day deadlines. If we were to put a deadline in there, what do you think is the appropriate before the hearing?
Yeah, that deadline would not upset me at all. I think that I actually appreciate it, because for my assistant state attorneys, we would have a date to work toward. So whatever that would be in advance of a hearing time, 15, 30 days, something like that, I think it would be totally appropriate.
From a practical standpoint, following up on that, is that significantly, so I'm assuming most places, I'm familiar more with some circuits than others, but I'm assuming most circuits have pretrial orders in these cases, setting by the court a deadline for filing motions and that sort of thing. And with trials being moved, one, is that your experience if there are pretrial orders managing when these hearings are going to be held, when motions need to be filed, that sort of thing? And from a practical standpoint, if those deadlines are now in rule, is that a significant difference from a daily practice perspective if trials are moved than you would experience under a pretrial order instead of a rule?
Right, and I think that this rule would help us with some inconsistencies. In my county of Polk, there's 6 separate felony divisions, 6 separate judges, and they try to be consistent, but one may offer the requirement of a pretrial order of a schedule, and one may not, and you have to know all of that, obviously. But when you have a specific time in the rule, it provides everybody with a starting point to work from, and I mean, I think there's a certain benefit to that. I guess I'm out of time, so thank you.
Thank you.
May it please the court, my name is Luke Newman, and I'm rising today to speak on behalf of the comments submitted by the Florida Association of Criminal Defense Lawyers. In general, as an overall approach to this proposed rule change, Factual is opposed to adding or potentially adding a myriad of different deadlines that could vary as frequently as the number of Florida circuit judges who handle criminal cases, and potentially block out rulings on the merits of these important criminal issues.
Can we address the first thing you said?
Yes, sir.
I'm not sure I understand. I'm not sure I understand why that matters. We require parties to be aware and to abide by the court's orders in every case. I'm not sure I understand what the particular hardship is of saying, oh goodness, this court, this judge has entered this scheduling order, I have to abide by it. You'd have to abide by the court's pretrial rulings. You'd have to remember, for example, if the court said, we're not letting you introduce 404B evidence or some other piece of evidence that you've proffered, you'd have to remember, oh yes, in this case, I'm not allowed to make that argument. Why is this a hardship?
Because it could preclude a ruling on the merits of the issues.
That's a separate argument.
Right.
I guess the argument that I have a hard time understanding is the first part of your argument, which you make in your papers, which is, oh gee, it's going to be so hard for defense lawyers to remember that this court has said that the deadline for filing pretrial motions to dismiss is 15 days before trial.
I just feel like that would certainly could create a hardship if an attorney practices in front of several different judges.
Every attorney practices before several different judges, hopefully.
Well,
if he or she is good.
Let me respond to that then briefly. I guess we're going to get on a little bit of an aside here. And a lot of times that's not the case with state attorneys and public defenders who are assigned to one division and have one trial judge.
Yeah, but you're talking about the hardship on you, on the defense.
Certainly, if you do practice in front of several different trial judges and you have several different policies that relate to pretrial motions that vary depending on which courtroom you're heading into, that certainly creates at least a potential for a pitfall where your client's not going to have his or her.
I'm afraid the practice of law is full of potential pitfalls.
I agree with you there, sir. Yes, sir. We're on the same page there. So I think, but I don't know that we should write them into the rule. So I think I don't know.
I don't know how you write a rule without writing. I just don't think this is a winner. That argument.
Is it your understanding and in your practice that these type of sort of strict pretrial orders are not as common in criminal law as they would be in civil court or family or any of the other civil side?
Certainly, I think that's fair to say.
They're much more flexible, correct?
Yes, ma'am.
Maybe non-existent.
I'll accept that. I have no trouble saying that that's my experience in practicing law. And let me bring up a couple other aspects that make the period of day deadlines difficult and hard to manage in criminal cases. And the first one, we haven't talked about this, but it's not uncommon to read an appellate record in a criminal case and see that a defendant is in a series assigned different appointed counsel, maybe a public defender's office at first, and then regional conflict counsel later, and then maybe if there's another conflict, then moving on to an attorney who's working on a conflict list. In that case, there's no guarantee that that defendant is going to be represented by the attorney who's going to be handling the merits of the case within 45 days of the arraignment. And so I think that that reality of criminal practice needs to be addressed too. You could easily have a defendant who shows up with it, finally gets a lawyer who can handle his or her case on the merits, who doesn't have a conflict, and you're at 45 days past arraignment.
You still have the good cause, out, don't you?
And so, I agree, there is a good cause
Your
out.
Honor, I'm brand new on this case. Can I please have an extra week to look at this?
That's how the proposed rule is written. But then here's the fear is, I'm bearing the fear. The fear is that then we're arguing about good cause. And the Factol's position is we shouldn't be arguing about good cause. We should be arguing about the facts and the law that apply to the motion. And so that's the fear. So that would be my response that, yes, we could talk about good cause, but should we be talking about good cause, or should we be talking about the law and the facts that apply to the motion that the defendant wants to put forward? And I want to submit another.
Can I ask you? I'm sorry to interrupt.
Absolutely.
You. So, but if you accept the premise that the nature of these things is that just as a matter of just efficiency and common sense, that there should be some kind of deadline in advance of trial so that you don't essentially put a halt to everything and have one of these hearings. I mean, if you don't like what the committee has proposed, what would be a reasonable alternative?
So let me clarify, if I might. Are we talking about the stand your ground kind of silo, or are we talking about technical defects?
The stand your ground. I mean,
so in stand your ground, Factol's position.
That's what got this whole thing started, right?
Well, there's a stand your ground proposal, and then there's this discussion about technical defect motion. I think the proposed rule also would address, and I know you made this.
So let's focus on stand your ground.
Stand your ground. Factol's position is that it needs to stick with the that there cannot be that the case law is, and I can't pronounce the name of the district court case. The case law says it just needs to be made before trial, and so that's the position. And we make that position not, flippantly, but because of the importance that the Florida legislature has attached to stand your ground.
Okay, but let's assume that we're persuaded that it just doesn't make any sense for someone to be able to come in at the 11th hour and file one of these things. You don't like the 30 days in advance deadline, right?
Correct.
So what's an alternative?
I think we go with what the district courts, at this point, what the district courts have told us.
So but the district courts are just interpreting the rule.
Understood.
Which the whole point of this is to decide whether to change the rule.
Understood.
Okay.
Yes, sir.
So so basically you're saying there's no way to accommodate this concern.
In the stand your ground context. And I think maybe the way to accommodate it, and I see I'm over my time, but I want to finish answering your question. If there's abusive practices, right, and I think that's the concern, and maybe that's a concern sparked the proposal to amend the rule, is that the defense counsel in some case filed a stand your ground motion on the absolute 11th hour, the night before trial or something along those lines. And I think circuit judges have the ability to address abusive practices without harming the defendant or removing a potential defense from the defendant. And so I understand that's a concern, and maybe that's the impetus behind the proposal to amend the rule. But I think that circuit judges have clubs in their golf bag that they can use to address abusive practices, frivolous motions that don't involve taking away potentially meritorious motions from a criminal defendant and subjecting him or her to incarceration.
Okay, you can have 2 more minutes to make whatever other points you want.
I wanted to then go back to something you had mentioned, Mr. Chief Justice, earlier about how the motion deadlines that are at issue today didn't address constitutional matters, a fundamental constitutional matters.
Sorry, I was talking about the stand your ground.
Oh, yes, sir. Yes, sir. I just wanted to make, my understanding was that their proposed amendment would add a potential for motion deadlines onto suppression issues in matters that were constitutional. That was my understanding. With that, I think we've covered what I need to cover in supporting the comments. If there are no questions, again, I'm over my time. I'll yield. Thank you.
Thank you.
Good morning, may it please the court. My name is Rich Manta. I'm here today on behalf of the chair of the Criminal Procedure Rules Committee, Judge Ward. By day, I'm a statewide prosecutor, but today I'm here on behalf of the committee. The committee reviewed the Criminal Court Steering Committee's proposal and by and large supports it. There were 2 issues that drew the most attention, I think, from our committee. as reflected in the comments. Number one was the time limit as it relates to when these motions need to be filed prior to trial. The majority of our committee felt that a longer deadline was necessary, a 60-day deadline, just due to the nature of how criminal casework proceeds. A minority thought a 45-day in line with the FPAA suggestion would be more appropriate, but nobody really raised too much squawk about whether to impose a deadline. I will note that almost all the associations you've heard from today are also represented on the Criminal Procedure Rules Committee. The second issue that the Rules Committee addressed...
Can I ask a quick question? I just don't remember. Was the 60 days for any type of case, even like a misdemeanor?
The 60-day proposal was brought up in the context of misdemeanors. There was enough concern that it would too greatly affect misdemeanor court proceedings and a shorter speedy trial scenario there that I think the committee believes that the Criminal Court Steering Committee's response to that is the more appropriate one. However, I will point out that the recent decisions as it relates to the speedy trial rules may actually alleviate much of that concern. The second issue that the committee took upon itself to really debate was the issue of whether or not the motion should be sworn. The majority of the committee thought it should be, and the remainder of the Criminal Court Steering Committee's proposals were
What animated that? Is it what Justice Kennedy was asking your colleague about earlier, about the sort of practical reality of if it isn't sworn, then it is more likely to be a vector for ambush?
It was not so much that, although I will say that did come up in the conversation, but the comment that has been previously referenced from our report sort of breaks it down and says, look, if you're prepared to advance this under oath at a hearing, you ought to be prepared to advance it under oath on paper prior to the hearing. There's no reason you shouldn't be able to.
And I apologize, this is tangentially connected to this, but it hasn't come up yet in our colloquy with any of your colleagues, and it's something of interest to me, and that's the subsection H, the depositions to perpetuate testimony and the use of communication technology. Do you have an answer to the confrontation clause issues raised by defense counsel?
On behalf of the committee, we did not address that issue specifically.
Okay, I'll come back to Judge Boulogne on that one.
But I would point out that the committee also asked that did express a preference that rulings, whichever way they go on particular immunity motions, be done in writing simply for purposes of clarity and for purposes of appeal. I know that the steering committee disagreed with that, but that was one other proposal from our committee. I would also point out that it did come up during the discussion and the debate that while this is a sort of immunity in particular is a specially conferred benefit from the legislature, it is not as though this court has not historically been required to circumscribe procedurally fundamental things such as insanity, such as alibi. Those are such a self-representation. Those are constitutional guarantees in some scenarios, and they still need to be procedurally implemented. And right now there is no rule procedurally implementing them. So with that, those were the primary issues that our committee addressed, and I'll stand by for any questions. Otherwise, we do stand primarily in support of the steering committee's proposal. Thank you.
Can I ask you, so it seems like we often have, in this case, it seems like there was a decision about stand your ground immunity, which leads people to look at stuff, and then we get a rule proposal that touches all these different things, everything from, deadlines for that, plus deadlines that affect all kinds of other motions and perpetuating testimony and having these the motions being sworn and everything. To the extent that we're just trying to kind of fix take things one at a time and fix a discrete problem that comes up, what would you say is sort of the mischief that we're trying to address? I mean, it seems like this thing kind of metastasized a little bit. I mean, what's the real, I don't want to kind of bias the whole thing, but what is the problem that led to us even needing to look at this rule?
I think the problem is that given this the stand your ground immunity sort of exemplifies but wasn't the sole representative of the issue. But the problem is that the system tends to collapse under its own weight if left unattended and left to be manipulated. What gets measured generally gets accomplished in the criminal justice system if there are calendar orders, if there are case management orders, and this is an effective tool to encourage and in fact mandate that. When tools exist that have the nuclear capability that a immunity ruling does, that tends to, it can't help but tend to disrupt the system and to rein in the chaos, I think, is the goal of the steering committee as I read their report.
But you're talking about the stand your ground thing?
Primarily, that's what kicked it off, but it is not as though there are not other rules, motions to dismiss, that fall into that same issue.
But I mean, do you feel like there's a significant problem in general right now with the system of, you know what I'm saying? I mean, it always seems, and I understand, I mean, once people start looking at things, everybody's got a different idea about, oh, well, we could fix this, we could fix that, but you know what I'm saying? It seemed like this started off as a narrow thing that common sense wise needed to be addressed, and now there's like all these other issues that are on the table.
I do think where the court has stepped in to provide structure and deadlines, that has been useful. The case counts are burgeoning everywhere, and management tools are extremely important in that regard, so yes. To answer your question directly, yes, I do.
Okay, thanks.
Thank you.
All right, well, I can ask this first. Any questions of any of the justices? Or
My confrontation clause question.
Yeah. If you look at the depositions to perpetuate testimony, there's a lot of qualifying language in there that there has to be a judicial finding of good cause for that, and make sure that the defendant's constitutional rights are not violated, and the witness and the defendant must be able to see each other during the examination unless the defendant waives it. I think there's actually more protection here than there used to be in the old days. If there was an elderly victim in the hospital or some sort of a ALF or something like that, we would just take a video camera and have it done there. And if the defendant's in custody, he's not even there. But now with the technology that we have, at least he'll be able to see that witness or that victim. And obviously, we're using Zoom for a lot of things, a whole lot more than we used to.
We perhaps shouldn't get into all of that.
Yes.
But, the concerns about witness coaching are not insignificant. One of my pet peeves about Zoom and its use in court is that counsel often has, a screen next to the screen they're looking at where they've got a chat open with someone who's feeding them answers, or Google, or any other number of things where, I can't tell on a Zoom call what they're looking at. And if they're alone in the room, there's really no way to quality control that. And I worry about that from a confrontation clause standpoint.
Right, well, I'm not a huge Zoom fan either, but in a situation where the witness can't be there because the witness is infirm, there has to be good cause for that. And if the witness really can't be there, then I think Zoom is a lot better alternative than not having Zoom, where a defendant has less confrontation than they would otherwise under the rule. Any other questions? I will say this. I don't agree that our proposal would make this into a C4 motion. Here's the thing that no one has picked up on that I've seen, and that is a C4 motion, by the way, it's now going to be a B3 motion. And the reason that we did that, I know that's going to confuse some people after all these years, but the reason that we did that was because under C, that was in regard to deadlines, and then B is the motion itself. So we thought it really should be under B instead of C. That may confuse some people, but we live in a society that where things are rapidly changing, and I think people can adapt to that. In regard to the trial judge being able to set these deadlines, I have a lot more confidence in the defense bar than they have in themselves. They can read the order. Right? There's going to be an order if a judge it does it. The justice is correct that in criminal court there are a whole lot less of these deadlines than in civil court. Basically, we deal with the rules, And that's why we're asking that these rules be modified so that at least people can file this in good faith, that we can have some assurance that people are doing this in good faith and reliable, and not just doing it to get a continuance or to try to harass the witnesses. So I don't think it's a solution looking for a problem. I think there is an issue. To be quite honest, we understand that there's a good cause exception. We also understand that on the appellate level, there's an abuse of discretion of a standard. Chances are we're going to allow them to do it anyway, but at least we can do this. At least we can admonish them for not following the rule. We can make them sweat a little bit. We can make them look not so good in front of their clients, and then maybe next time they'll follow the rule and not play the games that we're talking about. And of course, I'm not inferring or implying that all defense lawyers do this, because they don't, but some do with some of the time, and it really does create havoc in the system.
If we were to put a deadline on the traverse for the state, what would you suggest rather than reasonable time? That seems very vague.
Well, you know, it really all depends on when the defense files the B3 motion, formerly known as the C4 motion. If you say it's 15 days and they filed it in the last 10, and then they called and asked for a
What
hearing,
if we tied it to the hearing?
I would say yes. I would say at least within 48 hours. And the reason I say that is because there's really not all that much that the defense can do once the state does that. And by the way, they have to swear to it themselves, right? So if they swear to it, no, the facts are something different, and we don't agree that these are the facts, and I swear, then there's really nothing that the defense can do anyway. I mean, they can yell that it wasn't filed reasonably, but if it was filed reasonably, what are you going to do about it? And the answer is there's really nothing you can do about it. You just have a trial, and we see what happens. All right.
Okay.
Thank you.
Thank you so much to you and the committee for your work on this. We appreciate it. That's it.
Nice to meet you. Thank you.
May it please the court.
Oh, hold on a second. I'm sorry. There's some people, there's some people moving around and stuff back here. We'll give them a second to get their seats.
Well, while we're waiting for that, I have hearing aids, and the bailiff took the cell phones, and it occurred to me I can't adjust them at this point. So I apologize if I hate saying huh, or if I can't hear something, but my volume's a little lower than I would like. I think I'm going to be fine.
No offense will be taken.
I'm going to say the same thing, so speak up, please. Thank you.
Okay, so this is Florida Bar versus Clayman, number 2023-1219.
It is indeed. And if I may quote Justice Curiel to start out from something he said earlier today, due process requires process. And that's the vast majority of what I'm here to argue, is that the manner in which this case has proceeded has denied due process at every turn, starting principally with the District of Columbia, and that this matter should never have been brought. We've also argued that it's time barred. And without getting into the chronology in great detail, which we've set forth in the brief, there is no question about the fact that the actions that are the subject of these complaints that were brought by the District of Columbia involve matters that ranged in time from 2006 to 2010, some 15 years ago. There is also no question about the fact that the 2010 complaint, the Sataki complaint, was served in 3 different jurisdictions, including Florida, Pennsylvania, and the District of Columbia. The bar goes into great detail trying to argue that, as the referee noted in his early in the hearing transcript, that we have no conclusive proof that Florida actually received the complaint, but we have in the record a certified Florida bar complaint form that flat out says, in addition to making the complaints for Ms. Sataki, I have also filed complaints in Pennsylvania and the District of Columbia.
As an aside, Counselor, can you address the statement on page 72 of your amended initial brief that there is an absence of prior discipline when, in fact, the referee's report acknowledges that there was, in fact, a prior public reprimand? Is that an oversight?
Yes, it was. Okay. I learned about the earlier. It was quite a long time ago, quite frankly, and that should have been corrected.
Okay.
And we would have filed an amendment because there was, in fact, a very minor prior disciplinary matter involving a very limited sum of money, and the court basically accepted that there was nothing significant about it, and there was, I want to say, a public reprimand at that point in time. But yes, there was.
So on the issue of the complaint being sent to Florida, though,
sure.
If we think that the statute of limitations trigger for Florida purposes here, that the relevant date would be when the DC discipline happened, then this proceeding would have been within that. What's the relevance? So, and I know that you contest whether that's the relevant target, but if we think that that's the relevant target, then what other relevance would whether there was a complaint sent to Florida or not, what relevance would that have?
Latches. When you have somebody who's been subject to years of discipline in another jurisdiction, and then Florida's advised about that, the orders that were entered in District of Columbia, and does nothing for 3 years. To me, the idea that you're going to allow time is passing, memories are fading, documents are disappearing. The idea that you can come in and then say, hey, we're going to start investigating, we're going to start prosecuting at this point in time, when you've got a full-blown record laid out for you, suggests to me that latches has got to mean something.
So you would say latches starting from the...
I'm sorry?
You're saying latches as to the 3-year gap?
Yes. Yeah.
Okay.
Because of the time that was involved. Obviously, we've got a 6-year problem if you go back to 2010, and there's no question about a limitations issue. But the idea of latches is that you've got to move expeditiously, and you can't just sit on your rights. And when the clock is ticking, and Florida knows, without question, that there has been an extraordinary period of time from 2010, when the first Sataki complaint was filed, and the other 3 transgressions that were involved in Mr. Clayman's representation adverse to his former employer. One would think that you would want to jump on those actions, because if you look at, as a matter of fact, there was some really interesting language I'd like to quote to the court. I think it was in Randolph, where the court's talking about aspirational goals and how the bar has amended the rules. And what the bar is talking about is prompt prosecution of these bar complaints, because obviously, if a lawyer is doing something that is detrimental to the public at large, he needs to be disciplined. But the flip side of that, as the court notes in Randolph, is that the lawyer is entitled not to have to sit and wait to hear what it is that they're going to do. And what he says was, quoting Burton Young, who was working on the amendments to the bar, accordingly, with the powers of the new disciplinary rule, those who would trespass upon our ethics can expect to be called onto account immediately. There will be no more 2.5-year delays. Final disciplinary action will be complete within approximately 6 months.
Is there a case where we've applied latches as a defense in a disciplinary case? Is there a case where we've applied the doctrine of latches in a disciplinary case?
Not to my knowledge.
So why would we divert from precedent that takes into account the passage of time and mitigation, or in the weight the evidence is assigned, when we have, positive law, essentially a rule establishing a statute of limitations? What would be the justification for this court to set a new course and apply latches?
Because I think the idea of latches is that you can't always pigeonhole something directly into a statute. It's more of an equitable doctrine. It's the idea that something is just, if you look at the entirety of the situation, it's just simply not fair or reasonable. And that's the large part of what's going on here. You have people writing and saying, as a matter of fact, in a couple of the cases we've cited where the courts have thrown out disciplinary action, this court has thrown out disciplinary action for failure to promptly prosecute. In those cases, usually you're talking about matters that are really principally equitable. Was this fair? Was this process fair? In this case, Mr. Clayman was allowed no discovery in the D.C. action. He was not allowed to take any depositions. There's actually testimony in the record from one of the lawyers who was at the proceedings that they were bringing in documents from Ms. Sataki that they'd never seen, because they'd never been allowed to take her deposition, and they'd never been allowed any paper discovery at all. And by the way, that was not a court decision. That was a decision by the D.C. bar not to allow him any opportunity. Now, in what process, what planet are you required to go in and confront somebody who's accusing you of misconduct and not know what they're going to say and not have the documents that they're going to present for consideration by the panel? And that's what happened here in D.C. And that permeates this entire proceeding. By the way, he was denied the opportunity at every step of those proceedings to take any kind of discovery whatsoever. And,
I'm sorry to interrupt you. Can I give you I just want to give you a chance to address just something that I'm kind of struggling with this case, which is it seems like, there's some attractiveness to the idea that regardless of what happened here, that, it was a long time ago, there was discipline in D.C., adding 2 more years to it might be overkill. On the other hand, seems like there's no acceptance of responsibility, even as to the things that really aren't contested with the conflict of interest stuff. A lot of your arguments here are just trying to relitigate what happened in D.C., which, kind of goes against the idea of just saying, hey, look, be reasonable here. And so it seems like if we were inclined to essentially just treat this more as a matter of quote unquote what's fair, it seems like you're your arguments are kind of cross-cutting, and there's nothing. The more you try to relitigate DC, and the more you kind of don't acknowledge, any kind of wrongdoing or anything, the less attractive your fairness-oriented arguments. And I understand you're in a tough position, but could you just kind of, how should we think about that?
I think that, the quote from this court many years ago, that the process itself can essentially supplant formal discipline. If it takes too long, if too much time is spent on the process itself, and that's part of what we are arguing here. But I think when you don't have a proper record developed, and I think that question really goes to some of the separate claims that Mr. Clayman brought against his former employer. There's just this assumption that there was a conflict, and if you go through each one of the three of those separate events, I don't know that there was a conflict, and you can't tell from this record, because the reality is, representing somebody against a former employer is not a per se conflict, unless you've got some evidence that information that was gained during the course of your employment is somehow being used adverse to the former employer. We've had cruise line cases where the cruise lines went after former in-house counsel who have become plaintiff's counsel, and there's reported decisions saying that's not a conflict unless you're showing that there's information that was gained that's used adverse to the former employer. But that assumption was essentially made in DC, and it's been mimicked ever since. Another involved whether or not the mere fact that a contract had been drafted by Mr. Clayman meant that he couldn't represent someone adverse to Judicial Watch to talk about the fact that they were violating the contract. Those kinds of cases happen in Florida all the time, and lawyers are not necessarily disqualified. If they're going to become witnesses...
You're saying it happens all the time that lawyers draft contracts for one client and then sue the same client over that contract?
I've been representing lawyers for almost 50 years. Lawyers are routinely sued for getting involved in cases where they're adverse to their former employers. Some of them involve internal contracts, some of them involve internal organization. The question really becomes, is there anything that was involved in the prior employment that is necessarily going to be at issue in the new case? If that's the case, the lawyer cannot handle the case. That's a conflict. But there are other cases where a lawyer may be material witness to the creation of a contract, and the law firm that worked on that with him prosecutes the case, but that lawyer cannot participate at trial because he's a witness at trial. There are cases along those lines all over the state. They happen all the time. The conflict really becomes, are you using information you gained that would not have been public information? Suing somebody for creating a hostile work environment 3 years after you left is not a per se conflict. And there's not a hint in this record of what information would have been used that would have been adverse to Judicial Watch's interests. Nothing. It's just not there. And I can go on because
and you're welcome to keep going, but you're well into your rebuttal.
Oh, well then let me take advantage of rebuttal.
Okay.
May it please the court. Mark Mason and Shanae Henson on behalf of the Florida Bar.
Can I ask you a question?
Absolutely.
So is a 2-year suspension here necessary to protect the public, or is this more essentially just a punishment?
The 2-year suspension, as opposed to the 18-month, which was the recommendation, was the final finding.
18 months, 2 years, anything. I mean, given the time that's passed, et cetera, that there's already been the discipline in D.C. What's the point of adding on to that?
The referee's holding was that there were substantial aggravating circumstances that led to his decision to increase it to a 2-year suspension. It was already mentioned earlier, the refusal to acknowledge wrongdoing. That was a big one. The pattern of misconduct, we're talking about conflicts of interest that spread over the 3 judicial watch cases, and then it also included the the Sataki suspension order.
Yeah, but the case for protecting the public from harm seems to me to be substantially weakened by the delay that the bar seems to have taken in this matter. If Mr. Clayman, because of this conduct, was a substantial risk to the public, why did you wait so long to act?
Well, we didn't wait so long to act. What we did was we acted on the Sataki suspension order. What he's talking about with the 3-year issue was the Judicial Watch 90-day suspension order. And in that case, it came up during the sanction hearing that there was a question raised about, well, did you notify the Florida bar of this order? And he answered, yes, I did. But I filed a petition for a hearing, and I'd ask that you wait. Didn't follow up with us again. It fell to the wayside, and then when the Sataki suspension order comes in, we see, oh, he never let us know about the outcome of that petition for a hearing. It was adverse to him. And so at that point, we moved on both of them together, but we only sought the 18-month suspension when we took the case to the referee, rather than combining the two and stacking them, which was suggested in the initial brief. That didn't happen.
But now, the misconduct here, though, occurred when?
Right, so the Judicial Watch cases spanned from 2006 to 2008, and then the Sataki matter was mostly in 2010.
Okay, so now it's 2025, 15 years ago.
Right.
Was he practicing, I know that there was eventually discipline in D.C., but I mean, how many years was he practicing between 2010 and now? And I'm wondering, is there any indication of any wrongdoing in that time?
The 2011 public reprimand happened during that window.
The one here in Florida?
Yes, the one here in Florida that was referenced earlier.
What do we know about that case?
It was a public reprimand having to do with his failure to pay a client a mediated settlement. I believe it was around $5,000 that he said he couldn't afford at the time, so he just didn't pay it. And it took initiation of a bar proceeding before he eventually did pay it. So now what we're here on is substantially worse conduct. And I think that's part and parcel of, when you look at it, a public reprimand.
A mediated settlement over what?
It had to do with his representation of a criminal defendant who was unhappy with his services, and so it was agreed he would reimburse, I believe it was $5,000.
So what do we know, though, about what he's been up to since 2010? So you mentioned the 2011 issue. I'm just trying to get a sense of what because we're talking about, you know, on the one hand, the DC stuff is serious, and just speaking for myself, I'm not really interested in relitigating all that. On the other hand, we are being asked to tack 2 more years onto this to remedy or to address conduct that happened 15 years ago. And I'm just trying to understand, is there anything else? I mean, how long was he, how long for that interim time, I mean, how long was he able still to practice?
Well, he was subject to an interim suspension while the D.C. proceeding was ongoing, and I'm actually not aware of if he got readmitted. He's been suspended in Pennsylvania this whole time, where he was also licensed as well. So I can't really speak to what law he practiced once he was suspended. You know,
when did that start? When did the interim suspension start?
That would have been during the Sataki appeal, which would have happened in, I'm not exactly sure the year, to be honest with you. But it happened during the interim of the appeal of the Sataki suspension, which led to that the 2022 order. And so, you know, it went through this very long appeal process, which was part and parcel of the delay, because we were acting on a reciprocal matter. It's not about whether we received something in 2011, which is still just conjecture on his part. It was an unsworn document. It was referenced that, no, it was on a Florida bar complaint form. It wasn't. It was on a Washington, D.C. bar complaint form,
right.
unsworn.
So let's take
all
that. Let's assume that the bar acted within a reasonable amount of time when they brought this. Can you just, what is the point of 2 more years of suspension?
Yeah, the point of 2 more years has to do with the aggravating circumstances that was shown to the referee. I mean, it was the refusal to acknowledge any wrongdoing whatsoever. He's still framing it as though this is a political ideology witch hunt against him. There was the accusations against bar counsel that the referee referenced in the report of referee having to do with bar counsel tipped off witnesses I was trying to subpoena. Absolutely no factual basis to assert that whatsoever, and yet he said it anyway. And it was just that kind of conduct throughout the hearing, and this notion that, I was never entitled to any discovery. He's received hearings and hearings and hearings. The Sataki alone was a 6-day final hearing. And this notion that he wasn't entitled to any discovery, he has to take 2 depositions, and there's a rule in D.C. that said you need to show compelling need to do it. And he simply did not do that. You know, so there's this constant kind of overstatement of no discovery, no due process whatsoever. But it went through a 3-tier review process in Washington, D.C. When it comes to us, we're not looking to relitigate the case, and I'm not going to, bandy about on that point too much longer. We took it and we acted timely, well within, if you say 3-7.16 and the 6-year rule, if that applies at all, it would be triggered when we get notice of those suspension orders. We're well within that 6-year time frame. So what he's talking about is D.C. took too long. And their order said the delay was unfortunate. There's not really an excuse for it. But we have in our standards unreasonable delay. It's a mitigating factor at best. I'm not saying it doesn't apply, but it was not argued in the initial brief. It wasn't found in the report or referee. It can apply. But ultimately, when you look at all these aggravating factors, the selfish motive that he had with pursuing these complaints in D.C. and drawing up all this media attention and all that, and you combine it with this multiple offenses in this pattern, that's what the referee was looking at to say, this is worthy of rehabilitative suspension, and in this case, a 2-year suspension based upon the 18-month suspension order, his conduct during the proceeding, and his priors. They did a 90-day suspension and the public reprimand.
Could I ask a question? And I'm sorry if you've already said this, but I want to clarify. What is Mr. Clayman's current status with the Florida Bar?
His current status is he's licensed.
Okay.
Yeah.
But he's not, there's no suspension?
No, there's never been any action on his license by the Florida, other than the public reprimand in 2011. But yeah, no current action on his license. He hasn't received any penalty for it at this time. So, at this point, this is what the purpose of a reciprocal discipline is for. We don't relitigate. We accept the findings of guilt unless he can establish his burden. And his burden is grave injustice, a paucity of proof, a complete want of due process. That's what the case law says. He hasn't established that. What he's established is that he raised due process arguments in D.C., and they failed. It went through a 183-page order in first review, and then another order saying that order went recommending a 33-month suspension was too much. We're going to drop it to 18.
Sorry to interrupt you, but the logic, it seems like sort of the logic of the reciprocal discipline and the reason why we don't relitigate and all that is just the idea that, you have a problem in another state, you go through the process, it results in some kind of discipline. In a perfect world, if someone else with due process has already decided this person shouldn't be practicing and offering their services to the public for 2 years, you would want to protect people in Florida for the same 2 years. I think the problem here is the stacking of the time, especially in a context where the wrongdoing is from 15 years ago, basically. So can you address that?
Yeah, I think a lot of that has to do with the way these cases get litigated and dragged out for so long, very frankly. A reciprocal discipline should have been a very quick matter in which there would have been overlap.
Do you agree that in theory that if you're just looking at it from a common sense perspective, that, if DC thought that, the public needed to be protected from this person for a couple of years, that you would give Floridians the same protection, and then everybody moves on, and hopefully the person acts the way they should going forward? Isn't that the way ideally it should work?
Correct. In D.C., what they said in the suspension order, the Sataki suspension order, was that he needed to demonstrate his fitness before being reinstated to the practice of law. I think that's very fair to ask for in this case. The referee thought it warranted a 2-year. The bar requested 18 months, same as the suspension order, and I think that was fair based upon the pattern of misconduct that he's done here. We didn't add on the extra 90 days from the judicial watch suspension order he found. We recognize that one is a bit older, so we weren't going to push on that. But when he acted as he did in the proceeding, and it resulted in a very delayed proceeding, you know, it resulted in a lot of accusations thrown out about what bar counsel did with tipping off witnesses. The case is going to take longer. And so to complain that, well, now it's 2025, well, it's 2025 because he took 7 years to appeal just that judicial watch suspension order. There's specification to charges in 2013 on that one. And that's how long it took before a 2020 suspension order came out. He did a 3-tier review process every single time where it got written opinions all the way up to the District of Columbia Court of Appeals, and they ultimately concluded that was always going to take a substantial amount of time. He's not attributable to all the delay. I'm not saying that. I understand D.C. took a while to bring the case, longer than they should have, but he wasn't prejudiced by it. He's talking about lost documents, memories faded. They rejected those arguments. His recollection was fine. Ms. Sataki's recollection was fine. That was the finding. He didn't identify a single document he needed or that he lost. Why would he get rid of them? She made the complaint in 2010 and a supplemental in 2011. He was on notice of those complaints. Why did he delete records that he's saying he deleted? It doesn't make sense that he would do that because he was never told the case was closed out. So all these notions that these due process arguments resulted in a paucity of proof or a want of due process or grave injustice, these are just typical arguments that were brought and failed.
Go ahead.
I'm sorry. So what do you say in response to the counsel's argument that he was denied discovery? Would you specifically address that?
Yeah, and I'd like to be specific about it because the discovery he requested was to depose 2 witnesses. One was Ms. Sataki, and one was her psychiatrist, Dr. Aviera. With Ms. Sataki, with the rule being in Columbia, you need to demonstrate a compelling need. She was coming from California to D.C., and so the way they do it in D.C. is at the ad hoc committee, they put her on, they did her testimony, and then he did substantial cross-examination. And what I mean by substantial is she testified for 3 of the 6 days of that final hearing. He was not limited by what she said in cross-examination. He's exploring other avenues throughout that entire proceeding. Now, is that... You're
saying he basically got the discovery in the proceeding?
Yeah, he got the discovery in the proceeding. He was allowed to explore, and there was a break before they continued on with other witnesses so he could prepare his case in chief as well. With regard to the psychiatrist he wasn't allowed to depose, that was addressed in the suspension order. The testimony she would have offered was insubstantial. Most of it would have been privileged anyway, although he falsely claimed that there was no doctor-patient privilege regarding that doctor. But on top of that, he just wanted to explain that any emotional issues with Ms. Sataki, alleged emotional issues, were not his fault. It was completely irrelevant to what the rule violations were, which was a conflict of interest, which was frankly established just by his emails that he sent to her alone and nothing else. So there wasn't just no due process. He wasn't allowed to take 2 depositions. That was it.
So in the unusual situation here, though, I mean, if he got a 91-day suspension, he would have to show, if he wanted to be reinstated in Florida, he would have to show essentially that that the problems have been addressed. The bar would have a chance to look and see what he's been up to since 2010. They'd be able to see what the status of what's going on in D.C. and Pennsylvania is. I mean, why isn't that enough to protect the public?
I think it's not enough to protect the public just based upon what the referee found in terms of the aggravating circumstances. Mainly his refusal, but also the pattern. And just, this is someone who has had a lot of time to reflect on conduct that happened as early as 2006 through 2010, and he still has not acknowledged a single bit of wrongdoing.
It really sounds to me like it's almost more punitive, and partly just based on the behavior in this proceeding itself.
I think that the referee had a unique vantage point to gauge whether this is someone who should be given the shortest amount of time before petitioning for reinstatement or a substantial amount of years. And I think that the referee's report justified why he didn't just accept the 18-month suspension and decided to increase it to a tier 2-year recommendation. With that, I see I'm over my time.
I think I interrupted someone.
Okay,
Oh,
can I go?
I'm sorry.
Do you know when the bar got notice of the 2022 order?
Yes, actually. It was in October of 2022. It was one of his exhibits. If I can find it here.
Okay, so it was October of 2022 when you were aware of the DC discipline.
Correct. And in that letter in which he notified us, he also asked us to stay the proceedings while he did collateral attacks of it. So I just kind of wanted to add that in to explain.
So
a lot of the delay is not.
When did the bar get notice that it was done?
The October 2022 is when he notified us. That's when it was. That's when DC had concluded the Sataki matters. Yes, but he was still planning on suing in other avenues to attack the judgment, and he asked us to stay.
So it was
at that
about
point.
a year, almost a year after that you filed the petition for reciprocal discipline.
Our complaint for reciprocal was in August of 2023. So yeah, a little less than a year. Yes.
You can have 30 seconds to finish up if you want.
All right. I would just like to say in closing that I believe that the referee justified it with the case law, particularly the Rush case, where you're prioritizing a client's interests, or excuse me, prioritizing your interests over the client's to the detriment of the client. That was a 3-year suspension. I'm not suggesting he needs that much, but there is case law that the referee addressed supporting that, and for that reason, I'd ask that you accept the 2-year suspension. Thank you.
Thank you very much. Has your client been reinstated anywhere? And I apologize that I don't know this. Has he been reinstated in D.C. or Pennsylvania?
Yeah, Pennsylvania had a CLE requirement. That was all. There was no, I don't believe there was any suspension in the matter. I'm sorry? During the pendency of the appeal.
What about D.C.?
As far as I know, D.C. itself actually gave notice to both Florida and to Pennsylvania about the results. So it's not just a matter of...
No, but is he still suspended in D.C.? Has he been readmitted in D.C.?
As far as I know, he's not applied for reinstatement.
He hasn't applied?
I did apply. You did reapply? Okay. The problem I'm hearing with this is that if you don't get discovery in the first place and you're not allowed to take depositions, the idea that he may have been able to cross-examine this witness cold, Ms. Sataki in particular, really does very little in terms of due process. Because the reality is you don't have an opportunity to look at the documents. You don't have an opportunity to find out if she's got other documents. Even from the documents that are submitted by Ms. Sataki in this case, they are back and forth for a better part of 8 months throughout 2010 as to what's going to happen, whether or not it's going to happen, how it's going to happen. No lawyer in Florida is obligated to get a client's authority to do anything other than the ultimate goal that is the client's aspiration. You don't talk to the client about how you're going to prosecute every case that you're going to take on. But at the same time, you can't cross-examine anyone about what they believe their opinions were or what they were telling you to do when you don't have access to communications that were being had. For example, with her union rep, who testified under oath in this case, along with the young lawyer who went to the hearing about the hostility that was directed toward her and to him at one point or another by Judicial Watch. In fact, the lawyer who testified in this case testified under oath about the manner in which Mr. Clayman was treated by the D.C. bar during those hearings. And I would ask the court to take a close look at that testimony because it's very clear that things were, in this day and age when everybody talks about weaponization, it's the first time I've ever used that word in my life. If you look at the way this prosecution went down by the D.C. bar, there was nothing about it that was really afforded any manner of due process, and that resonates throughout this entire case. the concept of conflicts morphed and has morphed in this case. First, it was he was doing this for his own personal good or to advance his own reputation. Then it was because he had a romantic interest in Ms. Sataki. Judge Lamberth himself, who denied the motion on the conflict issues and denied the opportunity to take depositions, said that it was a close call. He has referred lawyers on multiple occasions to the bar.
Sir, I'm sorry to interrupt you. You can have 1 minute to finish up.
He felt that in this case, there was absolutely no reason to believe that, as the 11th Circuit, the D.C. Circuit noted in its opinion, any reason to believe that Mr. Clayman couldn't and wouldn't practice ethically and competently, and in fact commended the manner in which all these cases had been handled. So, you know, you look at all of these people who testified in this case, the only one who testified adverse to Mr. Clayman was Ms. Sataki. And she was impeached regularly, as was noted by the Court of Appeal, on multiple issues when confronted. Well, that's the whole point, is confrontation. To be able to confront someone, you're entitled to rudimentary discovery and at a minimum a deposition, and not have to do it cold.
Okay, thank you very much. We'll be in recess for 10 minutes.
Thank you.
All rise. The Honorable Court is now in recess.
I have
Florida Supreme Court is now in session. Please.
Okay, our final case today is number 2024-0160, American Coastal Insurance Company versus Patios West 1 Condominium Association.
May it please the court. Good morning. My name is Ryan Jones and I represent American Coastal Insurance Company. My apologies. Good morning. My name is Ryan Jones and I represent American Coastal Insurance Company. We're here to address a conflict between decisions from the 3rd and the 4th District regarding the requirement to submit a supplemental claim under the Florida statutes.
Now, counsel, let me ask you a couple of questions about this in the outset. Kind of gets to jurisdiction, but to start off, now the statute that this argument is over and that both these courts were addressing is essentially now a dead letter. I know it's not a dead letter in your case because it's the law that applied, but going forward, it's a dead letter. I mean, the whole statutory scheme has changed. It's just like this is a relic of the past.
I'd submit that it's not entirely, Your Honor, and the reason is that the new version of the statute still requires notice, but it changed what the definition of a supplemental claim is and a reopen claim. So the concept and the principle is still going to be relevant even under the new statute for purposes of what is required to provide
but there's
notice.
a whole new statutory scheme, and that would have to be interpreted in the context of that, the language in that statute. And I mean, this is a little opaque, what we have in this statute. You would have to concede.
Absolutely, Your Honor. And I think what we can do, though, is when we look at the plain language, because this is a statutory interpretation issue, which means words matter. And we look at the plain language of the statute, just as the court required us to apply the supremacy of text principle for statutory interpretation, we can use that to determine exactly what happened in this case and exactly what was needed.
But part of the issue I struggle with here is that this seems to be, you look at this statutory provision, and then you look at your policy provision. You basically parrot this provision in the policy. But it's kind of chasing its tail because it refers to notice in accordance with the terms of the policy. Well, what is that? Now, when I go to the policy, which you very helpfully included in this September 4 letter, the relevant provisions, when you go to the policy and what the policy says about notice, it doesn't seem to be what you're claiming it ought to be, because that says basically give us prompt notice of the loss or damage, including a description of the property involved. As soon as possible, give us a description of how and when and where the loss or damage occurred. That seems to be contemplating that you've got to say, last week the hurricane hit my house and damaged it. Right?
That's correct, Your Honor, but I'd submit that
is what the notice, and when you send the letter, or your, Sedgwick, acting for the insurer, sends this a letter to the insured saying, this is notice to reopen this claim, acknowledging what they sent you was a notice to reopen the claim. Those are the notice provisions that you cite in the letter. So I'm struggling how, when you look at the policy, which I think we've got to look at, and the insured is going to get the benefit of the doubt. If it's ambiguous in any way, the insured gets the benefit of the doubt. I just struggle with how you're going to win. So tell me why I'm wrong about that.
Absolutely, Judge. And what Your Honor quoted were the duties after loss. I believe it's the first and the second of the duties after loss. The relevant portion, though, I believe, is much later, and it's added through an endorsement. And what is added through the endorsement is the same language of the statute, as Your Honor referenced. The language of the statute is incorporated within the policy.
But that says notice in accordance with the policy, and the only kind of notice that's talked about in the policy is here. The only thing that's specific about the character of the notice.
Well, I'd submit there's one other thing that's very specific about it. In the statutory language, which is incorporated within the policy, yes, it says says notice within the provision of the policy and within 3 years. And then it defines what a supplemental or a reopened claim is. And I think that's the very key language, because it defines a supplemental claim as an additional claim for recovery from the same loss the insurance company previously adjusted pursuant to the initial claim. Now, that's very important. Again, the words matter because that definition distinguishes the supplemental claim from the initial claim. And what that makes clear is that the notice of the supplemental claim can't simply say damage from Hurricane Irma, because that's what the initial claim told us. It has to be something different. It has to be, as the words of the statute and the policy say, additional. And that's where I submit Patios West's letter falls short. It doesn't identify anything additional that's being claimed. And the words that they chose matter. They fell short of asking for something additional. In fact,
Counsel, I'm going to stop once I ask you this, but let me ask you about this conflict. And these cases they're a little hard to parse. But when you look at Goldberg in context, look at the whole thing. It seems that Goldberg is drawing a fundamental distinction between when coverage is accepted and when coverage is denied. And there they said that the dwelling coverage was accepted and there was a dispute over the amount. The personal property coverage was denied, correct?
Correct.
But they say that the statute that we're arguing about here, or talking about, only applies when the coverage was accepted. Doesn't apply at all. Doesn't come into play when the coverage is denied. Now, I'm trying to figure out how that fits in with Patios West, because it looks like here we know that there was a denial of coverage with respect to 17 of the 20 buildings, correct?
Correct.
So it seems like under Goldberg's going to be reaching the same result as Patios West did with respect to that. Wouldn't you agree?
Well, I'd submit that it wouldn't, Your Honor. And the reason is that when we look at claims, we look at them as a whole. And in this case, coverage was extended for the claim as a whole. With respect to those 3 buildings, that's where the covered loss occurred, and the others were denied.
Well, but but in fairness, Goldberg wasn't looking at it that way. They're drawing the distinction between the claim with respect to the personal property and the claim with respect to the dwelling. So I'm not sure that the way you're explaining that really fits with the way Goldberg was looking at it. At least, I mean, not clearly. They're drawing that distinction, and so and from what we see on the face of the opinion in Patios West, I'm not sure we can even tell that the dispute is not entirely a dispute over coverage, rather than a dispute over the amount of loss. It's kind of opaque. But that kind of gets me to the point. And I voted to take jurisdiction in this case, but I'm kind of wondering. But I want you to maybe address what I've said about that framework in Goldberg and tell me why I shouldn't be wondering about the jurisdiction.
Absolutely, Judge. Well, let's start with the jurisdiction, because obviously that's the most important part. So what we need is an express and direct conflict between the 2 cases. Goldberg basically says you need to have something more than simply saying, than to make a claim. You need to have something more than just a statement that I have a higher estimate. Patios West, however,
they say that you need to have something more, if there's a dispute over the amount.
Correct.
If coverage has been accepted and there's a dispute over the amount of coverage, correct?
Correct.
Okay.
Correct. Patios West, however, does not require that same level. All Patios West required was the letter that we have in this case, which did not make an additional request for recovery at all. So if we were to address those two in combination, if Goldberg were to look at the letter sent in Patios West, I'd submit that that would not be sufficient to have triggered the supplemental claim. At least not, and I understand Your Honor's distinction.
Because the Goldberg analysis, I mean, Goldberg seemed like the court thought that there really wasn't any claim made at all. And then it kind of listed the three possible things that could have been given, almost as if they could have been sort of substitutes for each other. I mean, in your case, there's no question that there was this claim, I guess, and it's just a matter of, did it also have to have, the extra information in there. So it seemed like, the way I read the two cases, that to me seemed like the reason why there isn't a conflict.
Well, I'd submit to you that there is, because in Goldberg, the coverage decision was made. What Goldberg held is that once there is a coverage decision, something additional must be requested. And it simply wasn't. There was nothing from the insured that said, I want more money for X, Y, or Z. In Patios West, there's also, after the claim decision was made, there is nothing that says, I want more money for X, Y, or Z. That's why the two are in conflict, because one requires the insured to ask for something specific beyond what the initial claim adjusted, and the other one does not.
Well, the other way of reading Goldberg, though, is to say that you have to just ask, period.
Correct.
And Goldberg didn't even, the way the court viewed what was going on in Goldberg, there wasn't even another request, much less getting to then to the next issue of, well, what exactly is it that you're asking for? I mean, here there was just no additional kind of ask, period.
Well, in Goldberg, there were two comments that addressed the claim. Number one was the call from Goldberg where he said, I have a higher estimate. And then number two, there was the letter from the lawyer that asked for, we don't know entirely what it was, but we do know that there was a request to preserve documents in there, both of which related to the claim, very similar to what Patios West did in sending in a letter that related to the claim. But the effect of both of those was not to request anything additional. And that takes us back to the language of the statute and the wording that is so important. An additional claim for recovery from the same loss that the insurer adjusted pursuant to the initial claim. That's the distinction, the additional claim, the initial claim. In both cases, we know what the initial claim is. It was whatever the insurance company adjusted and outlined in their coverage letter. What you need to make a supplemental claim is something asking for more, something in addition to that initial claim. That's where the language of the statute and the policy take us. And that's not ambiguous. We have to look for something more. That, I'll submit, is where Patios West letter falls short. It doesn't ask for anything more. The only comment it makes relates to damage from Hurricane Irma. That's what we had in the initial claim.
But again, the idea that they're not asking for more, obviously not with specificity. I mean, that's correct. I mean, no question about that. Correct. But you acknowledge that it's a request to reopen the claim. I mean, so they're obviously asking for more, not specified as to amount, not specified in any way. But it seems to me to be overwhelmingly obvious, even from the way that you responded to it, that everybody understands that they want something more. Isn't that, what am I missing when I look at it that way?
What we're doing right there,
I know you think that they need to be more specific. No question about that. But the idea that somehow you don't know that they want something more, that just escapes me.
And I think I can help Your Honor out with that, because the way that we get to the concept that we're now talking about is we know or we think there's something more there, is looking at subjective intent. What did they mean by that letter? What could it have possibly meant other than to request something more? And if we go down that analysis, it is a subjective inquiry as to what they meant or what my client understood.
Well, why don't you just ask them what they meant? I mean, because under the policy, you can say, give us chapter and verse.
And we certainly can, Your Honor, but the statute requires more than a simple placeholder.
Well, what do you think that the statute requires specifically?
It requires, exactly like it says, an additional claim for recovery.
And so what would that be? What would that include?
That would identify what they, the insured, are looking for beyond the initial claim. And that comes from the exact language of the statute itself. We have the initial claim, and everybody's going to know what that is. Again, we're looking at the statute in context. Everybody is always going to know the initial claim because there's a coverage letter. The insured, presumably, is going to know what they believe to be short about the coverage letter. They're going to know what additional they want, and that's what they have to say. I don't think it's possible to formulate exactly what that is because it's going to vary from case to case.
So you don't think it includes an estimate of damages necessarily?
Not necessarily. An estimate I'd submit would be sufficient, but it's not necessary. And we went through in our brief, that's why we went through in our brief several examples of what else could be a supplemental claim. The windows and doors from the Ironwood case, or the moisture damage in the Lemon case, or there was a string cite of cases we did that I know don't relate to this specific statute.
But it seems like to me you kind of changed your argument, because you originally, I think all along, have been arguing it's got to be an estimate because we got to know something. Now I understand you're kind of softening what you're asking for, but I understand that sometimes happens because you think if I ask for a softer version, that's easier to win on. So I understand that, but you have kind of shifted there. And to the extent that we're focusing, you're saying that the statute is so clear, that seems to cut against that clarity because it's a kind of a morphing. What it requires is morphing.
Well, Your Honor, I'd respectfully disagree about the change in the argument because at the trial level, the comments that were made are an estimate or something else. At the third DCA, counsel acknowledged that an estimate is not necessarily required. It is something more. And in our brief, at least I hope if we wrote the brief clearly enough, it was an estimate's not necessary. Again, it's sufficient. It's not necessary, but something more is required. And it could be an estimate. It could be, like, for example, the Ironwood case, we want windows and doors reviewed. The Lemon case, we want additional moisture damage in these specific rooms. Or any of the other cases that were cited where additional money was asked for, a proof of loss, an estimate, a proposal. Any of those things would do it, but none specifically is required. So I wanted to make sure that I'm very, very clear, and if we weren't in our briefs, I apologize, but the estimate itself is not absolutely required by the statute. What is required, though, is something additional that is above and beyond the initial claim. And I think that comes from the exact language of the statute itself. I see that I am into my rebuttal time, but I do want to make just a couple quick points on what the relief we are asking for is going to accomplish. It's going to do two things that I think are very, very important. Number one, it's going to give effect to every word in the statute. And that's very important, especially when we come from a supremacy of text principle. The second thing it's going to do is to give effect to the statute itself, because the statute, again, looking at it in context, it sets an outside limit on when claims can be submitted. And if we allow just any reference to the claim in a letter, it will act as a placeholder for some additional claim to be made later. And I would submit that type of a holding would eviscerate the entire statute and its point. So unless the court has...
Well, counsel, when we kind of take the cases as they come to us, and these two courts have kind of agreed to some extent in the way of address it. But at one level, I just have a hard time conceptualizing why they make a claim with you, absent something that specifically tells them they've got to do something different. You deny the claim in large part. Why they just can't go sue you? If the legislature wants to set up things that they've got to do before they go sue you, okay, well that's one thing. But it just doesn't seem like that's been clearly done here. Now, again, I understand that's not the way this thing got litigated, partly because I think of the way Goldberg had been decided. But just looking at it with fresh eyes, it's hard for me to see why they wouldn't have just been entitled to go to sue the insurer once you denied the claim. And then, okay, you've denied the claim overwhelmingly. Maybe there's a dispute about a little bit of stuff over here on those three buildings, but basically there's a predominant denial of the claim. Off we go to court. And then if there's going to be mediation or arbitration, whatever, then that's that. But so why is Is that crazy?
Not at all, Your Honor. And I think that's a very good point. And the most important part of that inquiry, I think, is that's not how the claim was litigated. And that's very, very important for this situation because of the appraisal aspect. In appraisal, this was a dispute between the parties of the trial court. It's really not in front of this court, but I believe it answers Your Honor's question. Because if a claim is denied in whole, it cannot go to appraisal. And I think everybody agrees to that. But if it's denied in part, it can go to appraisal, and both parts are considered. The position that Patios West took below is that this was denied in part. So it's part covered, part denied, the whole thing goes into appraisal. If it was litigated the other way, like Your Honor is suggesting, there would have been 3 buildings that arguably could have gone to appraisal and 17 buildings that arguably could not have. And that's simply an issue that we don't have to tackle today. The issue that we're after, though, I think I've articulated our position pretty well. And unless the court has any other questions, I'll save any time I might have left for rebuttal.
You can have 2 minutes for rebuttal.
Thank you.
Good morning, may it please the court. Paul Feltman on behalf of Patios West. I'm here with my business partner, Leo De Silva, and Benjamin Alvarez. And one of the things that you just said, Justice Kennedy, was they could have just sued them. They could have just sued them when this happened, but they made a supplemental claim. And the person who wrote this letter is a lay person, wrote a letter. They did cite to the statute, and they said, we want to make a supplemental claim. And what they got back was a letter not asking for any information.
Well, they said an abundance of caution, right?
Yes, an
That's
abundance.
like there's some base they're trying to get covered there.
Yeah. And then they never asked for the estimate on the initial claim, which is still right under the policy. And when they got this, they did not ask for an estimate. What they said was the eye of the hurricane hit Cujo Key at 9:10, and therefore anything after 9:09, they used the hour and minute. Anything after that was claimed, and this came in at 1:36 to them, that is the cutoff. And so they used, and if you look at the statute, it says, and I think this was the language, and this is my take on what they did. If you look at the language in the statute, it says you have to, in accordance with the terms of the policy, when 3 years after the hurricane first made landfall or the windstorm caused the covered damage. And I think they were focusing on that because all they focused on was timing. They never wanted anything else. And Mr. Hoff, who testified during the second hearing below as their corporate representative, said the initial letter he sent with the initial claim, this is not a request for information letter. We're not asking him for anything. We just went and did an inspection. The second hearing, he said, yes, what we were concerned about at the time was just the timing of the event and why, you know, was there something, the reason that he didn't get to us before this 9:10 in the morning when, you know, Cujo Key was hit with a storm these years earlier, 3 years earlier. So that was what was the focus
Counsel,
there.
can I go back a little bit to the beginning? Explain to me, what is the express and direct conflict that actually gives us jurisdiction to hear this case today?
Well, I argued 2 separate points as to why I thought there wasn't jurisdiction, Your Honor.
Yeah.
And the first one was just kind of on the face and what was presented below in the briefs, which was the insured in Goldberg had an estimate and they asked for an estimate and he didn't give them the estimate. That's a violation of the policy. That's not what happened here. So that's the first distinguishing part of that. And then there was...
But in fairness, counsel, the court didn't seem to focus on that. They recited that, but that didn't seem to be the way they reasoned to their conclusion, did it?
No. Okay. No, I'm just talking about what I see as, you know, a reason why there may not be a conflict here. And the other one was what the third district said, which was they said, we're going to say this was something he should have provided, this estimate, but we're not going to define sufficiency. And so the issue of sufficiency was what was decided by the Third District Court of Appeal. And if you look at the statute and if you look at the policy, and they could have written the policy with anything that they wanted in it. They are masters of their policies. They write them, they put whatever they want in them. And they could have written a list. There's a list in the brief of all of these things that they could have had. And you know what? All they had to do was list it in their policy. They drafted it. It's theirs. And to the extent that they didn't, it's construed against them because they didn't ask for that. And so the other point I wanted to make with regard to the statute is this particular notice of supplemental claim statute doesn't say provide an estimate or damages. But we know that recently the legislature passed the notice of intent statute, which there was an argument here, I think, within the last couple months on, where there is a very specific requirement that the insured provide the estimate with the claim and the intent to sue. And to the point of that is if the legislature, and that was 6270152, if the legislature wants to require more than mere notice, and we're talking supremacy of the text, they know how to do that. They know how to
counsel,
put it in
how do you respond to what opposing counsel says, focusing on the language of the statute, which is mirrored in the policy, that refers to additional claim for recovery? I mean, isn't there at least a plausible, and I'm not sure they win with plausible, okay? I'm not, but isn't there at least a plausible indication there that when an additional claim for recovery is sought, that you've got to specify what is additional?
Well, if you're a person reading your policy, because these policies are written for the residents of the state of Florida who purchase insurance, and in this case from American Coastal, and they see what they see here, unless notice the claim, supplemental claim reopened, was given to the insured in accordance with the terms of the policy, which was within 3 years after the hurricane first made landfall or the windstorm caused coverage. And then it just says, for purposes of this section, the term supplemental or reopened claim means any additional claim. What puts the layperson on notice that they want that to mean estimate, they want that to mean a description, they may want it to mean a lot of things, but again, going back to the fact that they're masters of the policy and they could have written whatever they wanted in there, that is the answer to the question, Your Honor.
And the language here actually points you to the policy.
Yes.
And
the statute,
their policy points you to the policy.
Right. And the statute, if they had put it in the policy, the statute would have incorporated it by its terms. I'm not getting a lot of questions, so unless I have some more, we would ask that the third district's decision be affirmed.
Well, you really, but you adhere to your argument that we do not have jurisdiction.
I have that argument as one of my arguments.
I understand that, but that's kind of foundational, right?
Yes.
You're not abandoning your argument.
No. The last time I was here, I was told that jurisdiction was improvidently granted on my case, so I'm very familiar.
You've been on the other side of that.
I've been on.
But you'd be happy. You'd be happy for that result in this case.
See, sometimes that's how the law works out. You're not happy when you're on one side, but you're delighted when you're on the other. So with that and with no more questions, I want to thank the court for the opportunity to be here today. Again, it was a pleasure.
Thank you very much.
I want to address the express and direct conflict because a number of questions have come up on that. And I think that the easiest way to explain that is the holding in Goldberg that we hold Goldberg was required to file a supplemental claim setting forth those damages he sought in excess of what the insurance company has already paid. That's the holding in Goldberg, and that's what it used to decide the case. Patios West, however, did not require the insured to set forth those damages that it requests in excess of what the insurance company has already paid. That's the express and direct conflict. And I think the reason that Goldberg is the better reasoned decision is because it draws and gives effect to the plain language of the policy, the additional claim for recovery, which is distinguished from the initial claim. The additional means something more. That's what this court ruled in the Sabalo case. It described additional coverage as coverage above and beyond the base coverage of the policy. The same concept applies here. It is something above and beyond what was in the initial claim. And that's something that is always going to be able to be known by the insurance company and the insured. That's the language that's important. It's in both the statute and the policy.
Would you have us adopt the language in Goldberg, though, that said setting forth the damages? Because it seems like that's not really what you're arguing. You're arguing additional information.
And it's, Your Honor, I think the issue with that, and I believe that language is appropriate, if damages is not strictly construed, because damages in most of the concepts where we've heard it argued or discussed throughout the course of these proceedings has referenced an estimate. But that's not necessarily true. To go back to the examples I gave earlier, windows and doors are additional damages, but there's no number attached to them. Additional moisture damage in certain rooms are additional damages, but again, there's no number attached to them. It is something specific that the insured wants above and beyond what appeared in the initial claim. And that, I think, not only gives effect to the words of the statute, but it gives effect to the entire statute overall. And again, the goal of that, read in context, is to bring finality to insurance claims, to put an end point where they can be reported. It's not to allow a placeholder to start the claim all over again. And that's why we think that Goldberg is the better reasoned opinion. And on the topic of finality,
so
I think
hold on, though. So how do we, so the initial claim, I mean, it seems like what's considered additional is going to be relative to kind of how specific the initial claim was, right?
Correct.
So if it's just sort of a broad open-ended, you know, the hurricane came through and it damaged my property, I mean, does that mean that there's kind of by definition, everything beyond that is just going to be an argument over the initial, kind of how the company is responding to the initial claim? Or, you know what I'm saying? Because I know that intuitively, I mean, I know that one way of looking at the additional is that it's something that you were kind of unaware of or something like that. But I'm not even sure if that still wouldn't be covered within what you say initially. You know what I'm saying?
I think I do understand the question. And basically, the answer is yes. Whatever is additional will vary from case to case. And the way that we find that out is we look at the initial claim, just like the statute definition says, the initial claim. In every case where we have a supplemental claim, we will have an initial claim and we will have a coverage letter. That will explain what the insurance company has deemed to be covered or not covered, or the amount of coverage. That kind of sets the playing field. Now, if the insured wants something more, something additional, above and beyond that, that's what they have to specify. In some instances, it may be something so simple as the estimate was $1,000 off, or you forgot to account for painting a wall in a certain room. In other situations, it may be you didn't pay to replace the roof, and you should have. You only paid to repair it. So it's whatever the insured wants above and beyond that. Because in this text, I know Mr. Feltman used the phrase, the master of the policy. The insured is the master of what they're claiming. They're the ones that are asking for something more to make a supplemental claim.
But if it can just be kind of, if it can be more sort of relative to what you gave, then why isn't, in this case, it was obvious that they sent something saying, you know, we're not satisfied with what you've done. I mean, I don't understand why that's not enough.
The reason it's not enough, Your Honor, is because if we look at what they said this is a claim for damage by Hurricane Irma. It doesn't say anything else other than damage by Hurricane Irma. That's what they reported in the initial claim. So the reason it needs to be more specific is, did we just miss something on building number 3? Should the roof estimate have been a little bit higher? Or was it building 12? Or was it the other buildings that we didn't extend coverage on at all? Was that what you're asking for, additional? We don't know what any of those things are. And again, this is to limit a claim, the outside end of a claim. It's not to start the process all over again, because this process is, again, looking at it in context, the insurance company sent a field adjuster, an engineer, a building consultant, all to inspect the property over multiple days, and at that inspection was the plaintiff's adjuster and another building consultant. So all of those individuals inspected all of this property, did all of this work, to identify what the initial claim was. And if there's something beyond that that should have been paid, Patios West knew that. They had their adjusters and consultants out there. They know what more they want, and they should just state it. It's that simple. If not, what the result of that will be to allow the placeholder letter to come in, and then 2 years later, the actual claim for damages, what they really want. And that's what we saw in this case, because the estimate didn't come in until 2022. And I know I used the word estimate again, but nothing came in saying what else it was. Was it building 3? Was it building 12? Was it all of them?
I understand this picture you're painting, but I don't. What I don't understand is why, when a letter like that got in, which is obviously just kind of a boilerplate, not real informative letter, other than saying we want the claim reopened, which all acknowledged is what it asked for. Why that doesn't just trigger the insurer to say, well, what more do you want? Tell us. And that's easy. That's not hard for the insurer to do that, because you're actually going to do this investigation about the timing of it all. When you get information about that, which it's got, I mean, that whole thing was just kind of a you're willing to do that, but when on the substance of it, what they want, you don't ask them about that. And I just don't, given the way the policy is structured, I'm just struggle with why that in this context. Under this statute, that's an unreasonable burden for the insurer to bear.
The reason, Your Honor, is because in order to get there, that allows the letter, a generic, non-specific letter, to restart the claim as a whole. It doesn't meet the statutory definition, the language, an additional claim for recovery. It does not make an additional claim for recovery, and that's what the statute requires.
And does the new statute kind of suffer from the same flaw?
Not exactly, Your Honor, because it uses two different definitions, neither of which is the current definition of supplemental claim. It defines a reopened claim differently than a supplemental claim and provides a little more specificity as to what's required for each of them. So it's really a different analysis than what we're focused on here.
So we need to be, I mean, obviously the parties here deserve justice in their case or whatever, but to the extent that we're worried about solving a kind of a policy problem, not insurance policy, but kind of public policy problem. It's like we're solving something that's not an issue anymore.
Well, I'd submit that it is still an issue, Your Honor, because there are many, many cases, what we call in the pipeline, that are either being litigated or one of the trial courts below, one of the appellate courts below, where this same issue still exists. And that version of the statute was in effect for quite some time afterwards, and we've had a number of other named storms that this is going to apply to. And the principle that we're talking about today does carry forward even under the new definitions, because we're going to have the same issue with what more do they want. And Justice Kennedy, I understand the concern about what this would do. But as we talked about, we cited the portfolio recovery case in our brief that Your Honor wrote. And there was a line in there that talked about, if that's what the statute requires, we're bound to follow. And that's what the statute requires here, an additional claim for recovery, and that simply wasn't made. So unless the court has any other questions, I thank you very much for the opportunity to present our case.
Okay, thank you very much. We're adjourned.